delighted here today to be with Lexpro Property Management and Chis Lubbe. We're here to discuss a digital platform, which is an accounting software program, but an accounting software program that is structured on the grounds of POPI compliance, and I think that POPI compliance is in the forefront for most South African property developers and estate managers, and so it is very important that we look at solutions around POPI compliance that can be integrated into the software and the designs that we already and systems that we already have available to us. So good morning, Chris, and thank you so much for joining us. Perhaps you could just let us know, introduce yourself and let us know a little bit more about Lexpro before we get into the meat of it.
Yes, thank you. Good morning, Louise, and good morning, everybody. As Louise said, my name is Chis Lubbe. I'm a director at Lexpro Systems, and we've been developing software for attorneys firms and for the property space for the past 25 years. The applicable software that we've developed for this talk is a property management system, which is used by homeowners associations and sectional title schemes. And yeah, we're going to look at POPI compliance as the time is running out. When we're looking at Information Acts, there are actually two applicable acts. The first one is the Promotion of Access to Information Act. And this act regulates what information should be made accessible to whom and by whom. Then it almost sounds like an opposing act is the POPI Act, which is the Protection of Personal Information Act. And this act regulates what information is held and why, how the information is held, and where the information is held. So you can think of the two acts as two sides of a coin, where the PAIA Act regulates what information can be shared, and the POPIA Act what information may be stored and how. Now, the effective date for the POPIA Act is the 30th of June 2021. Now, it's important to note that the POPI Act was enacted on the 1st of July 2020, and a year's grace period was given for companies to become fully POPI compliant, and that grace period ends on the 30th of June 2021. Now, the PAIA Act has been enacted for a couple of years, and if you already have an information officer in terms of the PAIA Act, it will also be the information officer in terms of the POPI Act. I'll give a bit more information regarding the role of the information officer in a later slide. Now, the right to privacy is a human right, and it is included in Section 14 of our Constitution. So the POPI Act is the practical implementation of this human right. So it regulates the unrestricted access and abuse of personal information. And I think most of you have been aware that a lot of companies are collecting a lot of personal information. I think many of you had the experience where you opened a new account or something, and then suddenly you get the plethora of telephone calls or email messages trying to market everything to you. Another typical example is if you search for something on the internet for a while, and then the next day the same service or product is being advertised on your social media platform. So the POPI Act sets out the conditions to lawfully and securely store personal information. Now, it's very important to note that you are allowed to store and capture personal information. It just has to be in a lawful manner, and the information has to be kept securely. The POPI Act also places an obligation on all organizations who store data to disclose data breaches. So if you are in an unfortunate situation where a data breach happened, either physical or you've been hacked, you have to disclose this data breach to the data subject, in other words, the people of whom you are storing information. And then the POPI Act also limits the use of the data subjects information. A typical example of this will be data collected by homeowners association for purposes to send out levy statements may not be sold to a company for the purpose of direct marketing. So you may only use the data subjects information for the purpose that it was gathered for. Every homeowners association and estate agent, and for that matter, every organization must appoint an information officer. That information officer must be registered at the information regulator. Now, I've spoken to Lexpro's information officer, and she told me that the registration can be done via the internet, and it's actually a fairly quick and painless process. The function of the information officer is to ensure that the organization is POPIA Act compliant. So they have to develop, implement, and maintain a compliance framework. The compliance framework will be the broad framework of how you're going to be POPIA compliant. And then they also have to create, implement, and maintain a POPIA manual. The POPIA manual will have more specific information on how this compliance will be done. For example, you have to note the purpose of the collection of personal information. Now, in terms of a homeowners association or a sectional title schemes, there are many reasons why you'll collect information. The main, obviously, is to send out levy statements, but it can also include things like informing owner or a tenant of problems, asking them to make improvements to the dwelling, or send out fines. Also remember that in a homeowners association or sectional title, if you have an access control system, you're also collecting personal information from all the visitors. So you have to note who are all the data subjects for whom you are collecting information. So the obvious ones for a HOA will be the owners and tenants. Don't forget about the visitors. And you also have to state what information is captured. So for an owner or a tenant, it will be postal addresses, email addresses, physical addresses, etc. And on a typical access control system, visitors' information can include biometrics, like a photograph of the face or the motor vehicle, registration numbers, telephone numbers, etc. The POPIA manual also will state with whom information may be shared and when. The information officer also deals with requests from data subjects or the information regulator. Data subjects have the right to know what information are being held about them. So any person for who the HOA is holding data can contact the HOA and request that they disclose what data is being held. And they can also request that the data that's being held is corrected. So one of the provisions in the Act state that you must hold accurate information regarding your data subjects. Now, a few practical thoughts. You have to get permission from the data subjects if you collect information for any other purpose than managing the scheme. Obviously, now if you're looking from the point of view of a homeowners association. So it's important to note here that you are allowed to collect other data, but you need permission. An example of that will be the office park where our offices are located is in the homeowners association, and the park publishes a kind of a telephone guide with the businesses, with the contact details and what type of business you do. And they are allowed to do it, but they need to have your permission before they can publish your information. Then it's important to inform residents if the information is being shared with the managing agent, especially if you are currently self-managed and then you decide to appoint a managing agent, it's important to disclose this to the residents and the tenants, and tell them that you're going to share the information to the managing agent, who will take over the writing up, for example, of the books and the sending out of the levy statements. Make sure that digital information is protected from hackers especially. Our recommendation is that digital information is saved on a secure cloud server. For example, our property management software is hosted on a secure cloud server. And what we've done is we moved the database to a separate server, which is not accessible via the internet. So it's only accessible via the software itself. All the requests and data flow to and fro the servers are encrypted, and the servers are obviously secured by secure usernames and passwords. If digital information is held on site on a computer, consider investing in encryption software, especially if it's stored on a laptop computer. The problem is if a laptop or another computer is stolen, even if the thief does not have access to a computer itself, so he cannot log in, the hard drive can just be removed and inserted into another computer or in a portable hard drive case, and then the information is accessible. So what encryption software does is it encrypts the hard drive. So if you remove it from a computer and you try to access the hard drive from another computer, it's impossible to do so. Then also make sure that your access control service provider is POPI compliant, and a lot of homeowners associations and sectional titles have apps as well. The same goes for that. The homeowners association will remain responsible for the information held by the access control service provider or by the app provider. And in this case, make sure that the data is not held in another country. In the residential estate where I'm staying, our app data was held on the servers in Malaysia, and they informed us 2 weeks ago that they're going to do an upgrade, and they moved the data through to South Africa. Then if you have physical documents, they should be secure, stored safely. It can be in a lock-up file cabinet or locked in an office. In the industry, we talk about the empty desk policy. So if you work with physical files should not be laying around if they contain personal information. So if you've used a file, it should be put away safely. And then lastly, information that's no longer used, or there's no longer a purpose for the information to be held, must be destroyed. There's actually an alternative to this. The Act makes provision for de-identifying data. So for example, on your bookkeeping software, you don't need to destroy your accounting records, and they can be de-identified. So if you look at historical records, you can still see the transactions, but you can identify the person who the information was stored for. So the information officer have a lot of tasks, and it's actually quite important. In the guidelines, it's recommended that the information officer be at least at a management level. And if no specific information officer is appointed, it's normally the CEO of the company, if it's a company. So in terms of a homeowners association, it will typically be the chairperson. We are busy developing information officer training, so that will be coming soon. So if you look at my contact details, please feel free to contact me if you need any information with regards to our information officer training or information on our products.
Thank you. Thank you very much. That was very thorough. So just to go back and ask you a couple of questions.
Yes.
Was there a reason why you can't store your data on a server outside of the country? I mean, it's very common practice that large, like the data's in the cloud and that's stored off multiple servers all over the place.
Yes, the POPIA Act makes provision for it, so you are allowed to store it outside of the country, but you have to have permission of the data subject to do so. So you can make it just a whole lot more complicated for yourself if you store it outside of the country. The two main cloud service providers are Amazon Web Services and Microsoft Azure. And both those companies have a footprint in South Africa, so you can get storage at both Amazon and Microsoft while keeping the data inside of the Republic's borders.
Although, would you not find that your access control company, you would then have to find out where your service providers were storing their data?
That's correct. That's why I specifically included it. Especially with visit information, you are normally not storing it yourself, but the data belongs to you. So you have to make sure that your service providers are POPI compliant.
And if we look at the Lexpro solution as a product,
yes,
the solution is it's a digital accounting software solution.
That's correct.
So and obviously the solution itself is compliant. Is that correct?
That's correct. So the compliance have a few levels. The first of all, we make sure that the information that you can store on the system is the relevant information that you need to store. So for example, we make specific provision for information that you need to send out levy statements and to get hold of the owners and tenants. But we don't really have space to store additional information, which is not necessary. And then also the data is being stored securely on a cloud server, as I explained. So we go through great lengths to make sure that the data cannot be compromised.
And the individual that is given the responsibility, the regulator within the business around POPI compliance,
yes.
Do you foresee that always being a physical person, or do you see that being a digital solution in the future?
As it stands at the moment, you have to appoint a physical person as the information officer. So in future, it might become digitized, but I think the idea will be that a specific person can be held responsible. And the additional responsibilities of such an information officer is to ensure compliance. So they have to physically make sure that the rules that is set out by the organization is actually being adhered to.
Mm-hmm. And what about social media channels? So a state has a Facebook page, it has a WhatsApp page. We did mention that the app itself, the storage of information on the app needs to be needs to follow the right compliancy, and most of the portal companies, large-scale portal companies, would ensure that using the correct database systems, to support them. But a Facebook page by an estate, is there a responsibility by the administrator of that Facebook page, so an estate employee, to be compliant? I mean, how do you be compliant around Facebook?
Yeah, with Facebook, you're normally not storing personally identifiable information about the owners or the tenants. So I will stay away from anything like that. So if it's only about promoting the estate, a Facebook page shouldn't pose too much of a problem. With something like WhatsApp, you're obviously storing people's contact details on the WhatsApp platform. WhatsApp messages themselves are end-to-end encrypted, so that's not too much of a problem. But what I will always suggest is, with something like that, get the express permission from the person before you add them to the WhatsApp group.
But does that permission need to be in writing?
As far as I know, it doesn't have to be in writing, but it will be preferable to do so, because if there's a complaint and you claim that you had permission and the data subject said you don't, it's a lot easier to prove your side if it's in writing.
So, sorry, with other social media channels, the information that you would have would be the person's name, surname, their email address, potentially photographs of them and their family. Would you not deem that personal information?
It's absolutely personal information, and if that's shared over a social media platform, you will have to have their permission.
Okay.
So permission is kind of the key to the whole thing. You can store most data of a person as long as you have permission for it. The exceptions are things like religious beliefs or gender information, etc., which is considered not necessary at all to have, unless you are providing, for example, a medical service. But that kind of fall outside of what most HIAs will want to keep anyway.
So, and the homeowners association can collect the information around the person's, obviously their details as it affects the unit and the management of that homeowners association.
That's right.
And anything beyond that, okay, anything beyond that is deemed unnecessary.
Yeah, there won't be anything around that will be deemed unnecessary, I kind of think.
Okay, so any financial information around that homeowner or resident is not required. Well, would be information required if there is a transactional relationship between the homeowners association and the resident?
That's correct.
Okay.
That's correct.
All
but
right.
For example, a resident's monthly salary will not be relevant probably to a homeowners association. But it will be if you put yourself into the shoes of a bank. For a bank supplying a loan, it is necessary information to supply the loan.
Absolutely. So how does the Lexpro system assist with POPI compliance? So if for a homeowners association or manager that's looking at implementing the system, what are some of the benefits that they will experience?
So the main benefits from a POPI point of view is that we store only necessary data. We store it safely, so even if there's a break-in and the actual computer is stolen, the data will not be compromised. And then we also provide for means to safely destroy or de-identify the data when it's no longer needed.
And just off slightly off the side, would you recommend to a homeowners association and their financial team to try and become as paperless as possible, if you can say that, to perhaps not have as much physical information and rather try and sort of create more digital information on their homeowners and residents?
I think in general, it's a good idea. Unfortunately, paper does tend to lay around and somebody can get their hands on it. That being said, the whole idea around paperless offices have been around as long as I've been working, and that's been for about 20 years. And the reality is, I think we are actually generating more paper now than in the past, with the ease of printing, etc. So I think it's a good idea, but it's possibly not very practical.
True. Yeah, you do try. We do try.
Yes.
It's us old people that are the ones that are standing in the way of paperless environments, because we still need to print everything. I speak about myself when I say old people. So this old person.
Yes.
Absolutely. Okay, well, looking forward, thank you very much for presenting around POPI. I think that it is something that it will have great benefit to our homeowners associations and sectional title developments. And it's certainly something that some who have had the early start in it are ahead of the track, others are scrambling. It just depends on, I suppose, the size of your team and the size of your budget and time you can allocate to this. Is there any other particular new acts or any other information that you see coming in the future around personal information or the storage of information? Do you see the POPI Act changing in any way? I know it's just being enforced, but so that people can be prepared, so homeowners associations are prepared for the future.
It's very difficult to predict if the act is going to be changed. It has been written quite a while ago, so it's been fairly stable. What you might just keep your eyes out for is how it's being enforced. Obviously, enforcement will only start now, and always when you look at enforcement, some of the rules will be enforced more strictly, and things will pop out what the regulator is looking at, what we might not have thought of previously.
Just off that, talking about regulators, currently CSAS requires you to send your rules and MOI through for confirmation with them, so for them to validate them. Would the POPI compliance include something like that, where the individual that's managing your compliance would need to submit some sort of report to CSAS?
I'm not sure, Louise. I actually don't know.
Okay, all right. I'll cut that question out.
Yeah.
Yeah. It sounds like, so I wonder whether it falls under your MOI or your rules, your requirements, maybe your rules.
At this stage, you don't have to. Your PAIA manual, so when I started out, I referred to the PAIA Act. You have to have a published PAIA manual. As far as my understanding is, you must have a POPI manual, but it doesn't have to be published.
So thank you so much, Chris, for sharing this information with us. We really, really appreciate it. I think that it will assist a lot of estate management that are looking for additional insight. Can I, in my closing statement, just to ask you, do you recommend that an estate that is in the process of becoming compliant works with a professional team around it?
I will absolutely recommend it. There is quite a bit of work that needs to be done, and a lot of people have done the basic frameworks and the basic POPI manuals, so it can benefit you greatly and reduce a lot of time and stress if you work with a professional.
Thank you so much. Thank you, and enjoy the rest of your afternoon.
Thank you, and same to you.